All right, let's break down a fascinating Irish legal battle that actually all started with a single, pretty simple question. But this one question spiraled into something huge, traveling all the way to the Supreme Court and, believe it or not, testing the very foundations of how lawsuits are fought in the first place.
So this is it. This is the question that kicked the whole thing off. The auditing firm, PWC, basically asked its former client, Quinn Insurance, hey, you're suing us saying your own financial estimates were wrong, so could you just tell us what specifically was wrong with them? Seems pretty straightforward, right? But this one request sparked an absolute legal firestorm.
And when I say firestorm, I mean just look at this number. The stakes here were absolutely massive. Quinn Insurance, or QIL, claimed that because its financial reserves were understated, the company ended up suffering damages to the tune of 800 million euros. Yeah, this was no simple disagreement. This was an all-out, high-stakes corporate war.
Okay, so before we go any further, let's get a handle on who's who in this drama. First, you've got Quinn Insurance, the plaintiff. They're a huge insurance company that, by this point, was in administration. Then there's the defendant, PWC, their old auditors. And in the background, you have two other important names. Millimans, they're the ones who did the original math for QIL, and Mazars, the firm that came in later and found what they said were the errors.
So what's this really all about? Well, at its heart, QIL's argument was this. Their financial safety net, it's called technical provisions, was way too small for years. And because of that bad information, they claimed they made catastrophic business decisions they never would have made otherwise. You can imagine, a case like this was going to be an absolute beast. Everyone expected it to last over a year and involve tens of millions of documents.
So we're all clear on what's at stake. But here's where the story gets really interesting. Because when that simple question from PWC, hey, what was wrong with your own numbers, actually got in front of a judge, things got, well, they got messy fast.
What happened next was wild. You had the High Court saying one thing and the Court of Appeal saying the complete opposite. The High Court was like, yeah, of course QIL has to answer. How can we have a fair fight if PWC doesn't even know what it's supposed to be defending against? But then the Court of Appeal just flips it. Nope, they said. That's evidence. You save that stuff for the trial itself. I mean, you literally cannot get two more opposed views on such a basic rule.
And the Court of Appeal had this analogy to back up their thinking. They said, look, it's just like a car crash. If you're suing a driver for speeding, you just have to claim they were speeding. You don't have to provide an engineering analysis of why their foot was heavy on the gas pedal. Makes sense for a car crash, right? But the real question here was, can you take that super simple logic and apply it to a hyper-complex 800 million euro financial case? That's the rub.
So now PWC is in a really tough spot. The lower courts are totally at odds. Their only hope left? The Supreme Court. But, and this is a huge but, getting into the Supreme Court isn't what it used to be. The rules of the game had completely changed, making it way harder to get your foot in the door.
Let me just show you what I mean. Before 2013, the path to the Supreme Court was pretty open. But then the 33rd Amendment to the Constitution came along. It created a whole new court, the Court of Appeal, which instantly became the new standard place for appeals. Suddenly, the Supreme Court turned into a kind of VIP club with a very, very tough doormat.
So think about what this meant for PWC. Their win in the High Court got overturned, so they lost the appeal. Now they're at the final boss level. They don't just get an appeal, they have to actually convince the Supreme Court judges that their case is important enough to even be heard. And that is an incredibly high mountain to climb.
And to get over that mountain, they have to pass this really specific constitutional test. There are only two ways in. First, you have to prove your case is a matter of general public importance. Basically, that it raises a legal issue that affects way more people than just you. Or second, you argue it's in the interests of justice, which is kind of a last-ditch safety valve for truly exceptional situations.
Okay, so two doors. Well, the Supreme Court slammed one of those doors shut pretty much immediately. They said this case didn't fit the interests of justice test. That's a last resort, they argued, to prevent a grave injustice, not just to fix a potential legal mistake. So, just like that, one path was gone. Everything, the entire appeal, now hinged on proving one single thing, that this was a matter of general public importance.
So this is it.
This is the final hurdle. PWC has to convince the highest court in the country that this fight, which, let's be honest, is about providing details before a trial, is something that matters to everyone. How on earth do you even begin to do that?
And you have to understand, what PWC was asking for here is so rare. Appellate courts really don't like to get involved in managing a trial before it even starts. It just causes delays and headaches. So for the Supreme Court to even consider it, this case had to be something truly special.
And this is the bizarre little twist that made all the difference. Think about how weird this situation is. This wasn't a normal case where the plaintiff says, you, the defendant, did something wrong. Here, the plaintiff, QIL, was saying, our own numbers were wrong, and you, PWC, should have caught our mistakes. That completely flips the script, doesn't it? It suddenly makes PWC's question, well, tell us what you did wrong, seem a lot more reasonable and a lot more central to the case.
So when the Supreme Court laid out its thinking, it all started to make perfect sense. First off, they pointed out that the lower courts had given completely opposite answers. That alone creates legal chaos that someone has to clean up. But more than that, they saw that the core question, how much detail does a plaintiff have to give, affects literally every single lawsuit in the country. This was the perfect chance to finally clarify that blurry line between a required detail and evidence for trial. It wasn't just about PWC and QIL anymore.
All right, so all of this led to the final decision in this preliminary but crucial battle. And it was a decision that would send ripples through the entire Irish justice system.
And the winner was PWC. The Supreme Court gave them the green light. They officially declared that figuring out the rules for providing these details, or particulars, was in fact a matter of general public importance. The gates to the highest court were officially open. The appeal was on.
When you boil it all down, this case really pulls back the curtain on the constant balancing act at the heart of the justice system. I mean, how do you make sure things are fair for the defendant, who needs to know exactly what they're accused of, while also protecting the rights of the plaintiff? And how do you do all of that efficiently, while trying to adapt old rules for our incredibly complex modern world?
And so this entire saga, which all began with that one simple question, leaves us with a much bigger one to think about. As our world and our legal disputes get more and more complex, how do we make absolutely sure that the basic rules of the game, the rules of justice, stay clear, stay consistent, and stay fair for everyone involved? That, right there, is the real billion